Hi guys, Elizaveta with you. Today I want to talk about the importance of full disclosure to your lawyer, so there's no surprises in court or just before the closing of the transaction, so on. So when I have clients that come for divorce, let's say, or custody issues or whatever, I ask them, you have to tell me the truth, like what's going on. Do you have anything that your spouse can use against you? Let's say we're dealing with a custody issue, and when a client comes, or they always say their story, right, their side of the story, they kind of forget to tell some important information, and then we find out, let's say my client has some I don't know, drug addiction or whatever, right? And this will come up in court for sure, because the other side will use it. So, or whatever addiction, or maybe there's some abuse issue, whatever. So I always tell my clients, you have to disclose to me everything you can, so I can have a full understanding of the situation, and I can have a plan for our case, how we're going to deal with it. Sometimes when they disclose too much, and that happens in cases, we cannot proceed with you because there's situations where we can identify basically fraud, and that happens on real estate transactions. And I almost got involved with that, and I understood that's what's happening, and I backed off. Like I right away said, I'm not proceeding. So that can happen. So sometimes clients say too much because they think it's your lawyer, I can tell them everything, and then I have to say, I can't act for you, and I don't advise you to proceed with that, right? But whatever they do, it's their thing. Whether I have obligation to report on each situation, it's for me to decide and discuss with the law society or get some guidance and so on. But luckily, I haven't had cases when I had to go and report somebody. So nothing happened in my practice yet. But there is a situation when if there is some abuse happening or whatever, with child abuse, there is obligation that a third party have to disclose it to certain authorities. Okay, so this is more like common in our practice would be real estate transaction, family matter, then immigration matter. When people come to us and we assist them with immigration matter, they trying to tell us some stories, and we see they don't match, so we have to be very careful with that. And then we see that there is some situation that you can proceed with it, we will advise them that we cannot proceed, and don't recommend them proceed this way either. Okay, so we would rather lose a client than get involved in something we don't want to get involved. So in a cases with a real estate transaction, what is important is to know the exact situation about the debt situation, like debt situation, the family situation, if somebody is going through divorce, or and it's better to know it in the beginning, because then we can calculate, first of all, with debt, if the debt is attached to the property, then we will have to pay it at the time of closing, right? Once we receive the money, we have to make sure we pay your debt registered on title. But some debt is really tricky. For example, CRA debt, if it's certificate of judgment is registered, so on the value we'll see it could be one amount, right, on the title, but then when we contact CRA to get a payout statement, it's usually more than less, unless somebody was paying towards the judgment. So then we have to negotiate with them, see what amount needed. First of all, you need to find out by the time of closing, how much is going to be owing, how much penalties, and on and on and on. And why it's important is because when I'm closing the deal, I have to promise the buyer's lawyer that I can give them a clear title, and there'll be nothing on that title left concerning my client. And what I experienced with CRA is that I cannot get any confirmation in writing from them telling me that if I'll send them a certain amount of money, they will discharge their certificate. It's all over the phone with an agent, and it's very I would say scary for me, because what happens, or as a lawyer, right? Because what happens is that once I promise to provide a clear title to another lawyer, and if I made a miscalculation, let's say, or a mistake, or I didn't contact all those creditors, right, and didn't get all the numbers straight, and I'm short, then there will be a claim against me. And then our insurance will be kicking in, and they will be dealing with it, because the other side shouldn't suffer, right? Because that was my, let's say, mistake. So that's why when we ask you, let's say, okay, when we get the deal, we will ask you if there's anything registered on the title. We'll see it, right? Because we're not gonna rely on your representation about that. We're gonna do a search, so we see how much taxes you owe, how much property taxes, right? And then we'll see on a property what is registered. Do you have a mortgage? Do you have a private mortgage? Do you have a loan? Do you have any judgment? Do you have any lien? Do you have whatever is there? We need to contact everybody who has a registration on your title, get payout statements, get the confirmation that they're gonna be able to remove it once they're paid, and only then we can close the deal. So the sooner we see this picture, the more time we have before possession date to have it all arranged. So with the private lenders, it's also could be tricky because of their interest, because we're dealing with another lawyer but not institution, right? When it's a bank, we send a letter to the bank, and within like 2 days they'll give us a payout statement, and we know that the bank will send us a discharge, or they will file it themselves at the land title's office. With a private lender, we rely on the other lawyer, and hopefully they have this discharge ready, because if something happens to that person, let's say we pay the money and the private lender dies, so it's all going to be delayed, or a private lender is out of country, or so that will be a little bit of a delay. I mean, it will be resolved, but we just rely, hopefully, that the other lawyer to whom we're sending the money is not going to release the money until he has or she has the discharge signed by the private lender. Because if money is gone, the lender is not there, we're not getting a discharge, and it's responsibility of the other lawyer. So I think nobody would ever release the money until they have that paper. So there is a lot of steps, we have to take to make sure that the title will be clear and we have enough money to pay everybody, so nobody is coming after us. And that's what we do during the busiest time in spring and summer, when we have lots of deals coming in. We'll have to make a lot of calculations. We have to make sure that we have enough funds. So always calculating something. Anyway, always dealing with the money. Also important for us to know is your marital situation. Let's say you are going through divorce or separation, right? And you maybe don't want to tell us about it for whatever reason. And then when it comes to dividing the money, whatever is left from proceeds of sale of your home, let's say, you all of a sudden tell us that there is a fight, who's getting what, and so on. So what can happen in that case, if you can't agree how to divide the money, we will have to find a solution to that, because we can't give everything to one party, or we cannot give it in whatever portions that you don't agree to. So therefore we have a paper that's called direction of proceeds of sale, what to do with this money, right? It's irrevocable. So when you meet with us, we would have all the debts that we have to pay, including our fees from this proceeds of sale, and then distribution of net proceeds. And then we'll say A amount goes to husband, B amount goes to wife, or the equal amount, or whatever you guys agreed. And if you at that point cannot agree, we can close the deal and say we'll agree later, because the money coming to you, it's not about paying debt, whatever. But the consequence would be that this money can be stuck at the lawyer's office until you resolve your issues. Let's say you cannot agree, you have to go to court. Then we have all this money sitting, and nobody will gonna get them until there is a court order, and that can be a while. Therefore, again, it's better to tell a lawyer in advance that you're going through separation, or you're not agreeing to divide it equally. So maybe we have to send you, if you have no lawyer, family lawyer, we have to send you for independent legal advice, because perhaps it has to be calculated in a certain way to take into consideration the equalization payment and all that stuff, which I'm not going to talk about in this video. But let's say if the wife says, I'm going to take only 20,000 and the husband takes 100,000, so we have to question why, and perhaps you'll need an independent legal advice, because we, in this scenario, acting only as the lawyers for your real estate transaction. We're not here to give you family law advice, even though I do family law, but in that particular case, I will not help you, because you retain me to deal with a real estate transaction, and I can't represent two parties in a family matter, especially when there is a conflict. So that's basically it. Taxes, there's also could be a lot of taxes. We've seen huge bills, like when people don't pay for a couple of years, could be 20,000, 15,000. So we have to make sure we pay that, because tax can be then liened on a property. And water accounts, so we've seen huge water bills. If you're watching my videos, you know we discussed it before. So because those water bills, maybe at the time of closing they're still as a water bill, but after the possession, that bill can be registered against the title, even though there is a new owner in the title, because the water goes with the land, it's not going with the owner, and becomes a registered lien on the title, and the person will be responsible for that. It doesn't matter that it was not his or her bill, it's going to be liened on the property. And therefore we have to make sure that we pay your bill. So if we do a search and it's only $500 and we know our client, we will advise our client just to pay it. Usually we hold for a $1,000 holdback, and until you prove us that you paid, if you represent the seller, we don't release that money. And some very unusual circumstances, there are water bills in thousands and thousands of dollars, and that of course has to be discussed. And for that amount, we don't we don't release that money to the client. We will attend and pay at the city of Winnipeg just to make sure that's paid, because there will be, of course, a trust condition imposed on me to make sure that that's cleared. So that's that. So tell the truth to your lawyers, I guess, or maybe it's not that even you're hiding something, but maybe you think it's irrelevant, but sometimes even some information can trigger something in our minds, okay, and that we need to think about, because you don't think about it because you don't know it can affect your scenario. But if you, maybe you should ask your lawyer, say, okay, what do you need to know about my situation, right? Or maybe a lawyer has a questionnaire. So or maybe a lawyer doesn't care, they're just gonna do your real estate transaction, not gonna bother with asking too many questions, and if something comes up, then they will deal with it when it comes up. So everybody has different approach. I ask too many questions, maybe unfortunately for me, because sometimes I lose clients over that, because I find out something that I can then go ahead and proceed. But that's how I practice. So I want to know everything I can that could be relevant to the case, because I don't want any surprises at the last minute. So let us know if you are selling or buying, and we can maybe help you. Bye.